Private nuisance is a civil tort where one person unreasonably interferes with another person's use or enjoyment of their land. As it is a civil tort, it is not a crime that you can be punished for in a criminal court. Instead, you can be sued for private nuisance in a civil court where you have to pay compensation to the victim of your unlawful interference, or the claimant receives an injunction, so you are forced to stop unlawfully interfering with their property. To establish private nuisance, 3 conditions must be satisfied. Firstly, the claimant must have a proprietary interest in the land. Secondly, there must be an interference with the claimant's use or enjoyment of their land. Thirdly, the interference must be unreasonable. The first requirement, that the claimant needs a proprietary interest in the land, means that they must be the freehold or leasehold owner of the land. So people who just live on the land cannot sue in private nuisance. The second requirement is that there is an interference with the land. Typically, any physical damage caused to the land is an interference. The same goes for an encroachment on land, where another person places something on someone else's land. An interference with the use or enjoyment of land is different, however, as it is decided by a case-by-case basis, where the courts decide what constitutes a valid interference, meaning there is no clear guidelines that determines what the interference can be. The courts have held that noise, smells, vibrations, smoke or pollution is a valid interference, but they have also held that obstructing a view, blocking light or interfering with TV signal is not an interference. The third requirement is that the interference is unreasonable. This is decided on a case-by-case basis where the court is convinced that the interference was unreasonable enough to justify a claim in private nuisance. The courts take into account many factors when determining this, such as the duration of a nuisance, where short-lasting nuisances won't typically be unreasonable. But the court has ruled in the past that setting off fireworks can be a nuisance despite them not lasting a long time. The courts take into account the locality of the area where the nuisance was committed, such as an interference that would be a nuisance in a residential area might not be a nuisance in an industrial area. The courts take into account the frequency and timing of the nuisance, so an interference that occurs repetitively at night is more likely to be a nuisance than an interference that occurs sporadically during the day. The courts also take into account the malice of the defendant, where the defendant commits an interference with the intent for it to disrupt the claimant's use or enjoyment of land. The courts also take into account the hypersensitivity of the claimant's land. For instance, if the land is being used in a way that makes it particularly sensitive to a nuisance, where that same nuisance wouldn't be an issue if the land was used in a normal capacity, then the court will likely decide that the nuisance is not unreasonable. Finally, the courts also take into account the public utility of the defendant's nuisance. For instance, if a cricket ground causes a nuisance by some balls going over the fence hitting other people's land, the court can rule that the risk of the balls hitting people's houses is outweighed by the utility of the entertainment that the cricket ground provides. If the court rules that an interference is not unreasonable, then there is no nuisance. There are 2 defences to nuisance, which the defendant can raise to quash the claim against them. Firstly, they can argue that their nuisance is permitted by legislation, such as the Civil Aviation Act 1982 says that a claimant cannot bring a claim in private nuisance for the noise created by an aircraft flying over their property. It is important to note that unless a piece of legislation specifically prohibits a claim in nuisance, then a claim in nuisance will succeed, since the courts don't like the idea that Parliament can give a permit to create a nuisance. However, if there is legislative authority for a nuisance, or there is some public utility, then the courts will not issue an injunction, and instead just reward damages. The second defence to a claim of private nuisance is prescription. This is where the defendant has been committing the nuisance openly, continuously, and without objection from the claimant for 20 years. But if a new party moves into the area where the nuisance is being committed, even if that nuisance existed for 20 years, the new party is a potential new claimant. So the clock for the 20 years resets, and a claim for private nuisance can be brought. If a claim in private nuisance is successful, then the remedies you can get are an injunction to stop the nuisance, damages to compensate for any physical damages, or damages to the loss of amenity created by the loss of the use and enjoyment of land. However, you will only be awarded this if the damages are actually calculatable, and usually you will only be able to get an injunction. Finally, the court can issue an abatement where the claimant is authorised to stop the nuisance, such as cutting down an encroaching tree branch on your land. To file a claim for public nuisance, you typically start your claim in a county court, where you file an N1 claim form, and the claim will be allocated to the small claims track, fast claims track, or multi-track, depending on the amount of compensation you seek. If you seek an injunction, then it will be allocated to the small claims track. Private nuisance is a common law tort developing through case law, but specific areas of law, such as noise complaints, have dedicated legislation which provides further rules and procedures. So a claim for private nuisance involves many other laws, which is why it is advisable to speak to a lawyer to understand your specific claim relating to the other aspects of law. If you found this video helpful, you may want to check out other legal videos on my channel.